First case on today's docket is cause number 24-60084, Deep South Center for Environmental Justice versus United States Environmental Protection Agency. Is the appellant ready to proceed?
Good afternoon, Your Honors, and may it please the court. I'm Kirti Datla for petitioners. I'd like to reserve 5 minutes for rebuttal. Petitioners are here today because EPA's approval action opens the door to and sets the rules of the road for a 0 to 60 acceleration in the permitting and build-out of Class 6 wells in this state. These wells inject highly pressurized carbon dioxide deep underground for permanent sequestration. In EPA's own words, doing so presents unique challenges, as does the task of permitting and overseeing these wells. Given all of this, the stakes were high when EPA sat down to evaluate whether Louisiana's program satisfies the Safe Drinking Water Act's requirements. EPA's decision fell short in 2 ways that go to the core of the program. First, EPA approved a state statute that waives liability in the circumstances where carbon dioxide begins to move after a well has closed. That is, when these projects have failed to meet their most basic purpose. Second, EPA was satisfied that the box-checking exercise in Louisiana's application demonstrated that the state has the necessary expertise and capacity to carry out this uniquely challenging, complex program from start to finish. These were errors, and this court should say so. I'd like to start today with petitioner's standing and then move to the liability waiver and expertise issues. Petitioner's case for standing is straightforward here. No one disputes, and in fact, Louisiana and its amici agree, that Louisiana plans to permit more projects and to do so faster than EPA would if EPA was running the program. The declarants in this case have identified specific areas that they routinely visit. They've identified projects that are proposed in those areas, and they've explained why those projects would destroy the recreational and aesthetic value of those areas for them.
Counsel, how do you get around the Food and Drug Administration versus the Alliance for Hippocratic Medicine case?
Certainly, Your Honor. So there's 2 theories of standing in this case. The first are associational standing theories based on the set of injuries that I've started to discuss now. The second theory of standing, which relates only to Deep South Center, is an organizational theory standing. So I've started with the associational standing theory because I think it's quite straightforward. And if you believe we have standing on those grounds, you don't need to reach anything else, but I'm happy to address organizational standing at the end.
You're probably going to need to address both.
I'm sorry?
You're probably going to need to address both.
Sure, happy to. So just to wrap up on associational standing, the injury, as I've explained, and I can just go through a couple of the declarations to lay this out for you. So for example, Scott Eustace is a member of Healthy Gulf. At paragraph 10 of his declaration, he explains that he routinely visits, for example, Lake Marupa and the associated wildlife area to swim, to fish, to boat. He also routinely visits East Grand Terre, where he participates in bird watching and dolphin watching. He's explained that there are proposed well projects at both of those areas, and that the wells and the associated infrastructure would destroy the aesthetic and recreational value of those areas for him. That is a straightforward case for standing based on environmental injuries.
But isn't your theory that the real problem here is at the certificate of closure stage? Like on the merits, the thing that you're really upset about is not the fact that the wells are being constructed or that the wells are being constructed by or being overseen and charged by the state of Louisiana. It is that, well, at the end of all of this, we're not confident that the state of Louisiana, the trust that's going to provide the liability protection, et cetera, et cetera, et cetera, the checklist that's going to go into the well closure, that's the real harm, right? Like that's the thing that you really think, that's on the merits, that's what you're really focused on.
So for standing, there's, I don't want to draw too much of a decision tree here, but for associational standing, there's multiple types of injuries here. The briefs that challenge our standing focus on the injuries that are related to the effects of the aspects of the program that you decide. But I wanted to start with what I think are the most obvious, straightforward injuries.
No, you're totally right. You should absolutely start with injury and you should absolutely start with standing. But you do have to connect the two, right? Like you have to be able to show that the legally protected interests that you're interested in, right? Bird watching, the recreational, et cetera, those are somehow connected to the legal claims that you're going to make, which aren't going to arise for decades.
Certainly, Your Honor, we have to show that they're tied to the action that we're challenging such that this court could redress those injuries by, in this case, vacating the action. The action that we're challenging here is EPA's approval of Louisiana's primacy application. And as we've just been discussing, that approval essentially guarantees that there will be more wells permitted and built out at a faster rate than if EPA was running these programs. And the injuries we've just been discussing flow from that speed and acceleration of the Louisiana program.
But isn't the injury what Louisiana would do after that? Isn't the injury the conduct of Louisiana in administering this?
So there's two sets of injuries that we're discussing here, one of which flows simply from the fact that, as I think is undisputed, Louisiana will permit more wells faster than EPA would. The briefs say something that, EPA issues maybe one permit every couple of years. Louisiana, in its application, said that it plans to permit at least 6 wells in the first 2 years, and the applications, and this is outside of the record, but the current status of the applications before Louisiana number in the 80s.
But you have to be able to show that the legal violation that you're pointing to is causing the injury, right? You can't completely separate them and say, I'm injured by the fact that there are wells, but my legal claim is 50 years from now, there will be a certificate of completion, and I don't know if I can have a citizen suit against the trust, right? They have to have some kind of connection where you can say that it's not just any injury, it has to be a legally protected interest, right? And so you don't have a legally protected interest in having more wells or fewer wells or wells that are administered by EPA or wells that are approved by the Biden administration or wells that are approved by Louisiana, right? You have to connect them somehow, and I don't understand the connection.
Yeah, the legally protected interest that standing cases refer to.
I'm sorry, can you?
Sorry, the
Keep your voice up.
Our reading of the standing cases is that when you refer to a legally protected interest, you're referring to both, the kind of compliance with the statute, but really it's the injury. The injury here is the removal of the aesthetic and recreational values. Standing is on the basis of the relief sought, and here the relief being sought is to vacate the agency action. There are cases like, for example, Duke Power, the Supreme Court case discussing a sort of constitutional challenge to a statute where the alleged injuries were environmental injuries, and the same sort of argument was raised. Well, the constitutional challenge doesn't have anything to do with environmental injuries, and the court said that's not how the standing test works. What you need for standing is to show that the challenged action has injured you in a concrete way, and that the court can redress that injury by, in this case, vacating the challenge.
Totally, that makes perfect sense. But the challenged action that you're talking about in all of these briefs is what happens at the end of the certificate of completion, not the fact that there's going to, like, if you could come into court and you could say, hey, judge, look, the statute says you can only build 2 wells, but they're going to build 4 wells, and that delta is what's going to hurt us because it's going to double the amount of CO2 that's being injected into the water, and it's going to create these, or to the ground, and create these recreational injuries. I'm perfectly with you. But if your claim on the merits is instead, no, 50 years from now, there's going to be this stuff with the certificate of completion, that has nothing to do with the recreational interests that are happening today. You have to be able to show that your legal claim is somehow tied to your injury in fact, right?
So I think our reading of the cases is that what we need to show is that the action has injured us. But even if you disagree with us, and what we need to show is that the deficiencies in the program, so even if you think of standing as being on an argument-by-argument basis instead of a action or claim-by-claim basis, then I think the arguments on the other side are sort of caricatures of our standing argument. So the arguments on the other side kind of glom up, for I think obvious optic reasons, onto this 50-year timeline in the program. So the first response to that is that Louisiana's statute specifically says that the certificate of closure issues in 50 years or any other time that the commissioner determines is appropriate on a site-specific basis. So I think the 50 is sort of a red herring for that reason. The second reason I think it's a red herring is that we have explained that both of the deficiencies in the program increase the risk of safety problems in these projects starting at time 0. And no one is disputing that the effect of removing liability affects how projects build. So no one is disputing that if Louisiana doesn't have the required expertise and capacity to carry out this program, that means that these wells and the associated infrastructure will be less safe and increase the risk to petitioners. The only thing that the parties on the other side that discuss standing dispute is a sort of generalized argument that 50 years is too speculative. But as we've already discussed, that 50 years is not dispositive here, and no one has disputed that the errors that we've discussed go to how projects will be built right now.
What is your basis for the contention that whatever injuries you might potentially suffer in the future couldn't be redressed by the trust?
Sorry, I couldn't hear you, Your Honor.
So I take it that your contention is that, well, maybe it's not 50 years. Maybe after completion, they're going to issue certificates of completion in 5 years. Okay, so we all look at the Louisiana provision that creates the trust and assigns the liabilities to the trust. What is the basis of your contention that somehow that wouldn't fix your injuries? And again, they're speculative, right? Because we have no idea what the injuries are. We have no idea when they're going to arise. We don't know when the certificates of completion are going to be issued. But whatever, I'll give you all of them. Let's just say, give all of you your best facts. The certificate of completion is soon. You have lots of injuries. Louisiana does a terrible job administering the wells. You still have the trust. And so what is the basis of your allegation that the trust would not make you whole?
So I think here we've moved away from standing into the merits.
Sure.
I want to make sure we keep those separate. But if we're just talking about the merits, I think that that our argument stems first and foremost from the plain text of the statute. So I think we do not read the statute to transfer liability to the trust. And there's a couple of the provisions of the statute that we think make it clear why we're right to be asking questions and why we were right to ask EPA to address this in the first instance, which it did not. So if you look at subsection 2 of the section 1109 of the relevant provisions of the Louisiana Code, it says the state takes on ownership of a project upon the certificate of issuance. Subsection 6 makes it clear that the state does not take on liability. Subsection 3 then says that the storage operator is released from any and all future duties or obligations and any and all liability associated with or regulated with the storage facility that arises after the issuance. Then Louisiana, I think, hangs its hat on the idea that the statute then says monitoring and site remediation become the principal responsibility of the trust fund. The statute does not use the word liability. Louisiana adds the word liability into its brief when it discusses this provision. So we think just by the plain terms of the statute, it does not transfer over liability in full to the trust fund.
But I guess, and I saw that in your brief a couple times, you point out, well, what about citizen suits? We should be able to bring citizen suits. Of course, if you did bring a citizen suit and you did prevail, you get to keep zero of those dollars, right? That money goes into the general fund, the general treasury fund, and its only purpose is to deter future violations of the Safe Drinking Water Act, of which subsection E of the statute seems to address all of this. It talks about operational and long-term inspecting, testing, monitoring, remediation, repairing, plugging, blah, blah, blah. So it seems to be doing exactly, I know you know better than anyone, Laidlaw says that the only purpose of those citizen suit remedies is to deter future violations, and all of the remedies in subsection E are forward-looking deterrence, protection, fixing, etc. So what I'm asking is, what is the delta? So
there's two sets of laws that are at issue. There's the waiver of liability as to federal laws. That's not just the Safe Drinking Water Act. Sure. As EPA's original 2010 rule acknowledges, there's potential liability under other federal statutes like the Clean Air Act, RCRA, CERCLA. All of those, in addition to forward-looking citizen suits that might be on the table, have things like emergency authority that EPA could use to remediate. So that's one set of things where it's just not clear, for example, that the trust fund is a suable entity, that either Louisiana or EPA could sue it. It's not clear that you could order injunctive relief against it, even the forward-looking relief that you're speaking about. The same would, of course, also be true of citizen suits. And then the second kind of bucket of issues where we think there's a delta relates to the emergency authority under the Safe Drinking Water Act. Under the federal program, absent any primacy for Louisiana, the way this works is that EPA always retains authority to go to a former owner and seek emergency relief when there's an endangerment to a safe drinking water system. And that includes things like ordering them to provide clean water when there is no longer any clean water. It's not clear, again, that you can get that from the trust fund. It's not one of the enumerated purposes of the trust fund in section 1110. And again, it's just not clear how you would get at that liability. So there is a delta.
I know we've moved on from standing, but I still would like to go back to the very first question that I asked, which is relative to Deep South, one of your clients. How do you get around on the standing issue, the Alliance for Hippocratic Medicine opinion?
Certainly, Your Honor, and I see that my time's running out, so I think I'm just going to summarize the argument and then otherwise rest on the briefs, which is that we read FDA versus Hippocratic Alliance to preserve organizational standing in cases where the action perceptively impairs a core service of the organization. And as the declaration lays out at paragraphs 12 through 13 and 19 through 20, a core service that Deep South provides is risk analysis, and it's explained why, given the deficiencies in this program, it's going to have to go in behind the Louisiana agency in each of these cases and make sure that the risk analysis accurately captures the risk to the communities it serves.
And do you think that's a separate injury than what the organization normally does?
Well, so under FDA, sort of, it always has to be true that that's what the organization normally does. That's you kind of can't spend your way into standing part of the opinion. And what this organization, one of the core business services that it provides is the provision of risk analysis, and that's the service that we think is perceptibly impaired by this.
And that doesn't fall right under spending your way into standing?
Sorry, I read the spending your way into standing to be about things like advocacy or just opposing or just litigating. I think the test is about whether there's a perceptible impairment of core business activity, and we think there is here. I'd love to be able to address the capacity issues, but if my time's up, I can do that on rebuttal.
Your time's up.
Okay.
Thank you, counsel.
Good afternoon,
You may proceed.
and may it please the court. Tsuki Hoshijima for the U.S. Environmental Protection Agency. The Safe Drinking Water Act sets out a cooperative federalism scheme to regulate wells used to inject carbon dioxide underground. EPA has set out a detailed set of requirements that states must meet to obtain primary enforcement responsibility, or primacy. Those requirements address the full life cycle of wells, ensuring that wells are located safely, constructed and operated safely, and then closed in a safe manner. EPA carefully reviewed Louisiana's program and concluded that it met all of those requirements. Now, all those requirements that apply throughout the well's life cycle are designed to ensure the safety of the well at every stage. And petitioners aren't challenging the Louisiana program's consistency with most of those requirements. They're not challenging the Louisiana program as not complying with the federal requirements for locating a well, for operating the well, and doing all of that in a safe manner. Instead, their challenge is really a narrow one. They focus principally on this long-term liability provision, and this only applies at the very end of the life cycle. Let me explain a bit more about this long-term liability provision, because it's important to emphasize the narrowness of its scope and when it comes into play. Now, it only comes into play after a number of things have happened. So let me explain what all of those things are.
Counsel, do you plan to talk about standing?
We don't object to the court deciding this case on standing, but we haven't taken a position on standing. Certainly that doesn't preclude the court from reaching the issue, given the court's independent obligation to assure itself of its own jurisdiction. But if I may, I'd like to focus my time on elements of the merits, which I do think some of them do bear on this question of standing.
All right.
Now, what happens in a well's life cycle is there's a lengthy period where carbon dioxide is being injected into the well. That could be many years. Only after that is there a long post-injection monitoring period. By default, that's a 50-year period after there's no more carbon dioxide being injected into the ground. That timeline can be shortened, as my friend on the other side has noted, but to shorten that default 50-year time period, and impose an alternative timeline requires significant site-specific data to show that a shorter monitoring period is sufficient to ensure safety. Whether it's 50 years or a shorter alternative monitoring period, once you get to the end of the time frame, the well owner or operator still has to make a demonstration to the state that the carbon dioxide is going to remain in place and that the well is safe. And if that demonstration can't be made, whether it's at the end of 50 years or the shorter alternative period, more monitoring is required until that assurance can be made. It's only after that assurance of safety can be made and no more monitoring is required that the closure requirements come into play. Now, the Louisiana regulations contain closure requirements that essentially reflect EPA's federal requirements for site closure. And there's not much dispute over that because the text of the state regulation by and large mirrors the federal requirements for closure. And it's only after all of those closure requirements are met that this state statute comes into play. So it's after this injection period, the monitoring and closure, at which point the state is able to issue the certificate of completion of injection operations. And even then, the effect of the certificate is limited. The certificate can only be issued if certain conditions are met, and that includes the safety requirements that are shown. So it only applies really to any liabilities that might arise after that point in time, which is to say any liability that may arise after the point at which the well has been shown to be safe to the state regulator.
Counsel, your friend on the other side says that, I hear you, there's a long road to the certificate of completion, but at the end of it, there's an extinction of liability to the well owner that it would arise under state law, right?
I think we would call it a conditional transfer rather than an extinction.
But either way, whatever comes on the other side of it, like, and I don't mean to get into a quarrel about labels, whoever's getting sued and whoever's paying, it's not going to be the well owner. It's going to be the state, the trust, something else, nobody, right?
That's right. And I think the important point is that at any point, it's going to be either the former well owner or operator or the trust fund that's going to be liable. And that's also the state's view on this state statute. It's in the state intervener's brief at page 28, where they say that either the fund or the owner-operator is going to be liable. So
but your friend on the other side says that by approving this plan this way, you have incorporated the Louisiana, she calls it a liability termination, again, whatever you want to call it, that the extinction of liability that would run against the well owner, you've incorporated a state law provision into federal law, and that somehow is going to trump a bunch of different federal statutes like obviously the Safe Drinking Water Act, but also CERCLA, et cetera. Can you help me understand? I wasn't sure I fully tracked your brief on this. Do you agree with this characterization that by approving the program in this way, you've adopted into federal law the state liability transfer provision?
No, that's not quite right. And understanding that requires a careful look at the incorporation by reference language, which is in 40 CFR 147.950. It says that the requirements of certain state statutes are incorporated into the Code of Federal Regulations. And the reason the word requirements is important is it mirrors some of the language in the statute that has to do with EPA enforcement of an approved state program. Specifically, it's Section 300H-2 of the Safe Drinking Water Act that gives EPA the authority to enforce requirements of the underground injection control program if the state doesn't. So what we have here is EPA's ability to enforce some obligation on the permittee if the state doesn't, and therefore those obligations that the state law imposes are incorporated into the Code of Federal Regulations. However, this Louisiana statute at Section 1109 doesn't contain any requirements on a permittee that EPA would come in and enforce. And so the incorporation language makes it clear that there's no liability transfer being enshrined into federal law. I think a couple of additional relevant points are that the state statute can't be read to be waiving federal liability on its own terms. And so we think the best reading of the state statute, even if it has potentially overbroad sounding language, is that the Louisiana legislature wasn't intending on doing that in the first place. And if the state law isn't intended to waive federal liability, then incorporating such a state law into the Code of Federal Regulations, which again, our position is that incorporation is not happening, but even if that were the case, that incorporation wouldn't give the state law any effect that the Louisiana legislature didn't intend.
So are you saying that the well owner, even after the certificate of completion, can still be amenable to suit under federal law?
The well owner can be subject to suit under federal law, that's right. Now, there are limits, though, to what kind of liability might arise that far down the line under the Safe Drinking Water Act.
What about citizen suits? Your friend on the other side is very upset about citizen suits. So could a citizen imagine the declarants in this very case, and they're still alive, and they're still recreating, and they're still, complaining about these injection sites 50 years from today. Could they bring citizen suits after the certificate of completion and the rigorous checklist that you led with? Could they bring a citizen suit against the well owner even after the certificate of completion?
We don't see how there could be a basis for a citizen suit at that point, and the reason is that the Safe Drinking Water Act's citizen suit provision allows a citizen to bring a suit to enforce a requirement of the Act's underground injection control program. Now, the certificate isn't going to be issued until after closure is complete in accordance with those regulations, and closure is the last phase of those requirements. And so by the time the certificate is issued, it's not possible for there to be a violation of the Safe Drinking Water Act regulatory requirements that a citizen could sue to enforce.
But EPA could designate the site a CERCLA Superfund site, right?
I believe so.
And then presumably all of the CERCLA provisions would continue to apply to the well owner?
We don't read the state law as waiving any sort of CERCLA liability that might arise in the future, and we don't think that anything in the Code of Federal Regulations gives the state law that kind of effect. I think it's also important to note that under the Safe Drinking Water Act, what does remain is EPA's authority to take emergency action in the event of an imminent or substantial endangerment. That's under Section 300I of the Safe Drinking Water Act. And EPA explained when approving Louisiana's program that even after the certificate is issued, EPA retains its authority to come in and take that emergency action. Likewise, the state law provides that the state retains its emergency authority even after certificate issuance. And so you also have those safeguards down the road to the extent that they become necessary. I think it's important to emphasize that EPA has taken a careful look at the state liability transfer provision because these state liability provisions are not per se unacceptable, but they do need to be appropriately crafted to be approvable by EPA. What EPA said in this rule is there may be certain circumstances that would make a state liability transfer provision inappropriately crafted. For instance, that would be if the liability provision could apply and a certificate could be issued too early, because if that were the case, that would waive some Safe Drinking Water Act regulatory requirements. But the state statute ensures that the certificate can't be issued until after all closure requirements are met. It would also be a problem, EPA said, if a state liability provision were to waive liability for prior noncompliance with the regulatory requirements, because that could also undermine the stringency of the state program. But again, the Louisiana statute expressly says that it doesn't waive liability for any regulatory noncompliance prior to certificate issuance. Ultimately, the question for EPA was whether the Louisiana program met EPA's minimum requirements, and EPA's minimum requirements only go to the end of the closure phase. There's nothing in EPA's minimum requirements for state program approval that requires any particular form of, for example, state tort liability to be available beyond the end of this permit life cycle. And so what we have essentially here is a set of minimum requirements, and there's nothing in the federal requirements that says, in all perpetuity, all forms of liability must be maintained. Now, if I may briefly speak to the state implementation issue, I think the key point on this second issue is that this is a judgment call for EPA based on EPA's experience as a regulator. EPA evaluates the state program submission and makes, I think, a forecasting judgment about whether the state has given enough information about its expertise and resources to ensure that the state is going to be able to implement the program. And this kind of judgment call, based on EPA's expertise as a regulator itself, is the kind of judgment that's entitled to deference. As a closing note, let me just reiterate that Congress intended, under the Safe Drinking Water Act, for states to have the opportunity to obtain primacy if they meet the minimum requirements. EPA determined that the state met those requirements, and for those reasons, we ask that the petition be denied.
All right. Thank you, counsel. Rebuttal?
Well, let's see.
Oh, I'm sorry, I missed somebody.
We've got a third. Louisiana.
Yeah. I was leaving out the whole state of Louisiana. Ms. Smith?
Thank you, Judge Graves, and may it please the court, Kelsey Smith for the state. As Judge Oldham said, injury is a great place to start, but it's also where this case ends. I would like to start with Deep South and how FDA, the Alliance for Hippocratic Medicine, precludes standing for that organization. FDA, the Alliance for Hippocratic Medicine, held that organizations cannot spin their way into standing by expending money in opposition to new policies. But Alliance also limited what constitutes a perceptible impairment of direct services, as described by Havens Realty Corporation, and described Havens Realty Corporation as an unusual case that should be limited to its context. Deep South does not fit within the narrow context of Havens. Its core mission and business activities are rooted in policy, as are all of its alleged diversions, such as training, education, outreach, and researching. But these also all fall within the ambit of Deep South's routine activities that are used to accomplish its mission of community education, participating in and encouraging engagement with governmental decision-making, and researching policies. Organizations like Deep South will naturally have to adjust course every time there's a change in environmental policy, but that does not give them Article III standing. Allowing standing in such a case would be like saying an administrative law professor has standing to sue every time there's a change in administrative law because she has to update her syllabus and change what she teaches, despite that being the very purpose of her job. This flouts the narrow and unusual Havens exception and would open the floodgates for any organization to challenge policy changes based on perceptible impairments. And both Alliance and this court's holding and Louisiana Fair Housing, the Azalea Gardens, make clear that such policy-based routine diversions are insufficient for Article III standing. Likewise, Healthy Gulf and Alliance for Affordable Energy do not have standing due to the one-step removed anticipatory nature of their alleged injuries. First, their injury is too speculative, as it lacks any geographical nexus and is therefore easily distinguishable from all of the cases cited in their reply brief. Petitioners seek to establish standing through the declarations that claim a member lives on or enjoys land near a proposed site for a Class 6 well. But the key word there is a proposed site for a Class 6 well. No permit has been issued in this case, so any area petitioner claims will be harmed by Louisiana's primacy is purely speculative and hypothetical. And without any concrete locations, petitioners cannot meet their burden of demonstrating that a member uses the area affected by the challenge activity and will face an imminent injury. And second, petitioners are not regulated by the agency action itself and are claiming an injury that relies on the actions of third parties who are absent from this suit, who actually will be regulated by the primacy program. This makes their burden to prove standing, and specifically causation, substantially more difficult. Petitioners' claims hinge on the future decision of industry participants to use faulty or substandard methods of construction and operation of their Class 6 wells. Their theory of standing rests on a highly attenuated chain of possibilities that requires too many dominoes to fall in order. And third, petitioners' injuries are not certainly impending. In the unlikely event that leakage does occur, despite following proper requirements, the transfer of liability would not occur until 50 or so years after completion of the wells. Petitioners might have sincere legal and policy objections to Louisiana's primacy, but under Article 3, those kind of objections alone do not establish a case or controversy. The injury in fact requirement prevents federal courts from being a vehicle for the vindication of the value interests of concerned bystanders. That is precisely what petitioners are trying to do here, so the court should dismiss their petition. And as for the merits, my friend on the other side walked through many of the subsections of the long-term liability transfer section, but she missed section A4. And that provision explains clearly how the release of liability works with the trust fund. And it says, the release from liability will not apply if the trust fund has been depleted of funds such that it contains inadequate funds to address or remediate any duty, obligation, or liability that may arise after the issuance of the certificate of completion. And read as a whole, it is clear that owners are released from liability only when the trust fund can sufficiently address or remediate liability. And that remediation becomes the principal responsibility of the trust fund, who shall use the funds in accordance with the purpose of the chapter, which is to assure the compliance with the Safe Drinking Water Act. EPA has repeatedly responded to petitioners' concerns, both about the long-term liability provision and Louisiana's ability to implement the program. And throughout each time, EPA has come to the same reasoned conclusion, that Louisiana's Class 6 primacy program meets federal requirements and can be adequately implemented. The state asks this court to dismiss the petition for lack of standing, deny on the merits, or remand for revision. Thank you.
Thank you, counsel. Rebuttal, maybe?
I'd like to touch on 3 areas during rebuttal. On standing, Judge Oldham, I just wanted to give you the citation for the case that I mentioned earlier. It's the Duke Power case. It's 438 U.S. at 78. I also think there's a D.C. Circuit case that might be instructive on this point. It's Wild Earth Guardians, 738 F. 3rd at 308. And the only other point I'll make on standing is to say that any representation that we did not articulate specific projects is inaccurate in light of the declarations. Paragraph 10 of the Eustis Declaration, paragraph 8 of the George Declaration, I think make that quite clear. On the merits, I think what was striking about EPA's presentation is that none of the explanation that EPA gave today, which mirrors the explanation in its briefs, can be found in the administrative record. If you look at pages 707 and 708 of the Federal Register Notice, which is where EPA discusses the liability waiver provision, it does not say that there's a sort of Schrodinger's liability waiver here where you open up the trust fund, peek inside, decide how much money is there, decide if it's enough to tackle the problem at hand, and transfer liability back if the answer is no. That is nowhere in the explanation, nor does the Federal Register Notice say that EPA did not incorporate these provisions into federal law, thereby sort of solving the preemption argument that they give today. Those all, those are the kinds of arguments that were raised in the comments and that EPA needed to respond to. So the straightforward way through the merits is to say that these were substantial comments that were raised below that EPA did not respond to. The last thing I'll say on this front is that I think it's pretty telling, actually, that this kind of Schrodinger's liability concept is not embraced by API, is not embraced by the Louisiana Oil and Gas Association. And I think that's because this is not what any company would want. The reason you want a liability waiver is to have certainty, and this interpretation doesn't give them certainty. But again, you don't have to agree with us to rule on the merits. All you need to do to rule for us on the merits of this claim is to say that these specific concerns were raised in the comments, and they were, that EPA had a duty to respond to them, it did, and that EPA did not, which I think is quite clear from the 2 pages of the Federal Register notice that I provided to you. So last on this capacity claim, I think EPA has a fair point when it says that sometimes these kinds of decisions are ultimately judgment calls. But as the State Farm decision makes clear, you can respect an agency's decision and still also be cognizant of and pay attention to the lack of evidence in the record to support them. And this is, I think, one of the most straightforward failure to respond, failure to consider a certain aspect, an important aspect of the problem claims that you will see. So if you look at JA 605 through 606, this is where Louisiana gives its description of its program, and it says what expertise and capacity it has. This is why I refer to it as a literal box checking exercise. Louisiana says monitoring, check, there's a little check. Sometimes for consultants, there's also a check. But we in the comments, and the comments are at JA 1, 8 through 9, 19 through 20, 30 through 34, and I say that just to prove that this was an important point below in the administrative record. We said, given the scale and the ambition of Louisiana's project, given the fact that this technology does not exist at scale throughout this country, given the fact that EPA itself has recognized that the Class 6 well program requires specific expertise that may not be available given how few of these projects there are, EPA needed to at least ask for more than checking the boxes, and it didn't. EPA's response in the Federal Register notice just says, Louisiana has capacity. That's it. If EPA had done its job, asked questions, made a judgment call, we would not be raising this claim, but that's not what happened here. So with that, we'd ask you to grant the petition for review.
Counsel, I wanted to make sure you had a chance to get out everything you wanted, but I do have one question that came up in EPA's submission. They say 42 U.S.C. 300I gives us residual power under all circumstances, no matter any other provision of law, to take whatever emergency powers we need to take to protect drinking water. What is your response?
So I think we would say that the text of the waiver liability is broad enough to conflict with that provision, but if you disagree with us about that, we would appreciate your putting it in the opinion so that EPA and Louisiana are both held to that in the future. It also does not resolve the claim about liability under other federal statutes, of course. Thank you, Your Honors.
All right, thank you, counsel.